Welcome to African Today, the voice of a changing continent. We bring you the stories shaping Africa's present and future, from breaking news and bold analysis to culture, innovation, and voices on the ground. We're here to inform, inspire, and amplify the heartbeat of Africa every single day. Thank you for stopping by the channel. We hope you enjoy our video. Let's begin.
On the 22nd of September 2025, the Alliance of Sahel States, AES, comprising Mali, Burkina Faso, and Niger, announced their joint decision to withdraw from the Rome Statute and exit the International Criminal Court, ICC. The move signals a dramatic shift in how these countries view international justice and raises serious questions about accountability, regional politics, and the protection of human rights in a region already beset by conflict. This article examines the background, rationale, legal implications, and risks associated with the withdrawal, and offers reflections on what it means for the future of justice in the Sahel. Backgrounds in the ICC, the Alliance of Sahel States, AES. The AES is a bloc formed in recent years by the military-led governments of Mali, Burkina Faso, and Niger, especially after a series of coups across those states between 2020 and 2023. These governments have sought to distance themselves from former French influence in the region, abandon regional institutions such as ECOWAS, and adopt a more self-determined posture in foreign relations. The AES also plans to establish its own Sahelian Criminal and Human Rights Court, CPS-DH, to handle terrorism offenses, war crimes, crimes against humanity, and genocide, essentially an indigenous alternative to the ICC. The International Criminal Court, ICC, was established by the Rome Statute in 2002 to prosecute individuals, including state actors, accused of the gravest crimes, war crimes, genocide, crimes against humanity, aggression, when national jurisdictions are unwilling or unable. Under the terms of the Rome Statute, a state party may withdraw by notifying the UN Secretary General. The withdrawal becomes effective 1 year after that notification. Importantly, withdrawal does not relieve the state of obligations incurred before the effective date of withdrawal, for example, ongoing investigations or cases initiated while still a member. To date, other African states like Burundi in 2017 and the Philippines in 2019 have also formally left the ICC, citing similar concerns of bias, selective justice, or politicization. Motivations for withdrawal. The AES states have offered a combination of ideological, practical, and political justifications for their exit. Some of the key arguments they present include selective justice, neo-colonialism. They accuse the ICC of being a tool of neo-colonial repression, pursuing certain states or individuals, especially in the Global South, while remaining silent on serious abuses committed by powerful or Western states. The AES communique states that the ICC has transformed into an instrument of neo-colonial repression in the hands of imperialism. Assertion of sovereignty. The exit is framed as a reclaiming of national and regional autonomy to fully assert their sovereignty, they argue, implying that external judicial bodies represent interference in domestic affairs. Distrust of Western institutions. The withdrawal fits into a broader geopolitical reorientation, distancing from former colonial powers, especially France, and institutions perceived as dominated by Western states. Creation of regional mechanisms. By establishing the CPS-DH, the AES states claim they will have a justice mechanism that is more attuned to local realities and less susceptible to negative influence of imperialist powers. Frustration with the ICC's performance. The AES states argue that the ICC has failed to prosecute some of the gravest crimes, in their view, and has shown relentless pursuit of certain actors outside its favored circle. Legal and practical implications. What happens during the 1-year period? When a state notifies the UN of withdrawal, there is a 1-year grace period before withdrawal becomes effective. During that period, the state remains bound by its obligations under the Rome Statute. This means that any crimes committed before the effective date remain under ICC jurisdiction. Investigations already commenced must continue, and cooperation with the ICC can still be demanded. For example, Mali has an ongoing ICC investigation into alleged war crimes in its northern region since 2012. That investigation is unaffected by the withdrawal announcement and remains binding on Mali until withdrawal formally takes effect. Limits on future jurisdiction. Once withdrawal becomes effective, the ICC's jurisdiction over crimes committed after that date would typically no longer apply to those states unless accepted via some other mechanism. This closes one international avenue for accountability for future atrocities. However, it's important to note that territorial jurisdiction still applies. The ICC might still have jurisdiction over crimes committed on the territory of a withdrawn state if the crime involves nationals of states that remain parties, or if the situation is referred by the Security Council. This depends on the Rome Statute provisions. Impact on victims and access to justice. Those who suffer war crimes, crimes against humanity, or genocide in those countries may lose one significant international recourse for justice, especially if domestic courts are unable or unwilling to prosecute. Amnesty International argues that the withdrawal will not affect cases already underway, but will significantly harm the prospect of victims in future of being able to seek redress at the ICC for future atrocities. Credibility and implementation challenges. Implementation of CPSDH. The success of any regional mechanism depends heavily on impartiality, capacity, and political independence. If controlled by the same regimes implicated in abuses, it risks becoming a tool of impunity. International response and isolation. Other states, human rights organizations, and the ICC member community may respond with diplomatic pressure, sanctions, or reputational consequences. Non-recognition. Many external actors may refuse to recognize or cooperate with domestic or regional trials seen as lacking independence. Strategic repercussions. The shift may push the region further away from international norms and reduce incentives to reform domestic justice systems. Risks, critiques, and counter-arguments. Undermining accountability. Without the ICC's external oversight, the political cost for perpetrators of serious crimes may decline. Critics view the move as a retreat from global norms to shield power holders from scrutiny. Lack of trust in new institutions. Many observers will doubt that the CPSDH will be truly independent, given the same regimes are calling for it. The risk is that it becomes a vehicle for suppressing dissent or selectively prosecuting enemies. Violations don't disappear. The underlying conflicts, violence by armed groups, counterinsurgency abuses, forced displacement, remain, with civilians bearing the brunt. Removal of international oversight may exacerbate impunity in such contexts. Selective narrative and political messaging. The claim of selective justice is politically persuasive, especially in post-colonial contexts, but it often disregards the structural difficulties and resource constraints that ICC and other courts face globally. Legal ambiguities and gaps. The withdrawal does not immune states from all responsibilities. The interplay of territorial jurisdiction, Security Council referrals, and residual obligations under the Rome Statute creates legal complexity. Regional and global repercussions. Precedent for withdrawal. The AES withdrawal may embolden other states dissatisfied with the ICC, especially in the Global South, to reconsider their participation. Fragmentation of international justice. The shift toward regional courts and away from universal institutions may lead to a more fragmented system of accountability, potentially weakening global norms. Geopolitical realignment. The move cements the AES states' alignment away from Western multilateral institutions and toward alternative alliances, e.g. with Russia. Diplomatic pressure and isolation. Other ICC member states, UN bodies, and human rights groups may mobilize diplomatic pressure, sanctions, or public condemnation. Impact on civil society and victim groups. NGOs, activists, and survivors in those countries may find themselves with fewer international partners or legal recourse, potentially shrinking civic space. Conclusion and reflections. The AES withdrawal from the ICC is more than a legal maneuver. It is a political declaration. From the perspective of the governments of Mali, Burkina Faso, and Niger, it is a statement of defiance against perceived external control, a recalibration of sovereignty, and an attempt to localize justice. From the perspective of human rights defenders and international actors, it is a deeply troubling turn, raising fears that the constraints on impunity are being dismantled in a region already struggling with violence and weak institutions. In the year ahead, much will depend on how the withdrawal is formalized, through notification to the UN, how effectively the AES implements its alternative court, and whether external actors can maintain pressure to ensure that justice, not impunity, becomes the default posture. If you like, I can convert this into a publishable newspaper article, policy brief, or academic piece.
Thank you for watching. I hope you enjoyed it. Please like and subscribe to help grow the channel. Until next time, see you soon.